Good morning. Thank you everyone for joining us. I think that we've pushed the right button so you can now see the presentation, at least the first page of the presentation. My name is Steve Werth. I'm an attorney at Solmeyer Kupitz.
And my name is Magdalena Bordeaux. I am a supervising attorney with Public Counsel's Debtor Assistance Project. Thank you for joining us today.
And we're going to talk to you for a little bit about the dischargeability of student loan debts and bankruptcy proceedings. We all know why we're here. Every one of you know a lot about this topic, and the reason we know that you know that is because this is something that's now being talked about daily, weekly, nationally. Student loan debt now tops credit card debt. It's 1.2 trillion and growing. It's not just us telling you that, it's not just you knowing that, it's bankruptcy courts noting that fact in decisions about whether or not to discharge student loan debt.
And just to give you an indication of how high the student loans that students are taking out are, the college for the 2014-2015 academic year, the College Board reported that the moderate college budget for an in-state public college averaged around $23,000 a year, while a budget for a private school college averaged $46,000. So it's no surprise that we now are in a position where we have 1.2 trillion in outstanding student loans, especially since so many students now have to finance their educations with student loans.
And simultaneously with this explosion in debt, you've got increased scrutiny on these for-profit colleges like Corinthian, which recently filed bankruptcy, and you've got a lot of discussion about those types of places, whether the education is worth it, whether or not the debt was a fair debt to incur. So it's just coming up a lot, as we all know.
And which is why now the bankruptcy courts are, with recent cases that have come out and we'll talk about later, re-examining the circumstances in which a debtor with significant student loan debt, oftentimes decades old, can discharge their liability in a bankruptcy case.
So courts are, because of all of these changes, even in the last year or two, you can see in the cases that courts are struggling with whether or not things should change. And if things don't change, what you've got is a test, two different types of tests that we're going to talk about later in the presentation that makes student loan debt pretty difficult to discharge.
Right now what we want to go over is give you a historical background regarding the undue hardships test and how the student loan debt dischargeability exception arose in the bankruptcy code.
So prior to 1976, you could discharge student loan debt like any other debt. And in 1976, Congress passed the Education Amendment Act that made student loan debt that was less than 5 years old dischargeable only if there was a showing of undue hardship.
Now at that time, that legislation was driven by this notion that there was this fear that people were graduating with student loans and quickly rushing to the courthouse to file for bankruptcy and discharging those obligations without giving enough time to see if those obligations could actually be repaid. So a lot of that information remains questionable as far as whether that was actually happening, but nonetheless, because of the hysteria that happened as far as allegations of abuse and students rushing to the courthouse, Congress quickly passed the Education Amendment Act of 1976, which covers the exception that Steve just delineated, and then which was later then codified the following year in 1978 under the Bankruptcy Code 11 U.S.C. Section 523A8.
So we'll get to Section 523A8 in a slide or two. That's where the word undue hardship shows up. While we remain on this issue of the timeline, I wanted to point out that in 1990, Congress extended this period for loans to be dischargeable only with a showing of undue hardship to 7 years. And then 8 years after that, in 1998, Congress eliminated the expiration date entirely. So starting in 1998, we have the situation we now have, which is no matter how old your student loan debt is, no matter how old, 20, 30 years, doesn't matter. You can only discharge it upon a showing of undue hardship.
And then in 2005, that exception was then extended to private student loans, And this is where, as student loan was growing, it really exploded. In a 2009 Harvard study for for-profit schools, it was shown that students leave for-profit colleges with higher levels of debt than students in community colleges. They also default at a higher rate, and students who attend for-profit colleges are more likely to be unemployed, and if they are employed, receive lower wages. So that combination of factors that existed with regard to students attending for-profit schools really caused an explosion as far as the outstanding student loan debt.
So the statute that we all work under, and there's only one of them, is the 523A8, which is now on your screen. And the two magic words are the term undue hardship that shows up in 523A8. It just says a discharge under this title doesn't discharge an individual debtor from any debt relating to a student loan, and that's under 523A8A and B, and we'll get to that in a second. Unless accepting such debt from discharge under this paragraph would impose an undue hardship on the debtor and the debtor's dependents. So this is the statute that we look at. This is what Maggie mentioned before was the term that Congress adopted in the 1976.
It is important to note that at the time that this term was adopted, there was no definition of undue hardship under the Bankruptcy Code. So courts were really left to wrestle with defining the term and what a debtor needed to do in order to demonstrate undue hardship.
Yeah, Congress, I guess, must have just thought that the courts could figure it out, because there was no definition of undue hardship at the time. There still isn't. There is, after 523A8 was enacted, there was another section to which Congress used the term undue hardship.
And under that section, under 524, apologize there, which relates to reaffirmation agreements, the courts looked at undue hardship and basically looked at, I minus J, which is the income and expenses, and really looked at to see whether in a reaffirmation agreement, this is where a creditor asks a debtor to reaffirm a discharged debt in post-bankruptcy. And really the concern of the court was, in order to protect the fresh start of the individual, they looked to the debtor's income minus their expenses, and if there was no monies left after making that deduction, then the court said that posed an undue hardship, a presumption of undue hardship.
So for all of you strict constructionists out there, there's not much in the Bankruptcy Code itself to look to when you're trying to convince a court that undue hardship has a certain meaning that's found in the Bankruptcy Code. You can refer to Section 524 and then what Maggie just spoke about, which is looking at the debtor's income minus expenses. But because of this, because there's no actual definition in 523A8, you can see the courts have just been have had to come up with their own definition. So the first time this happened in a way that was adopted by other people was in 1985, in which where the Southern District of New York, in a case called In re Brunner, and it was later adopted by the Second Circuit, so that's the Brunner test that many of us know about and is the main test for determining whether undue hardship exists. The district court is the one who came up with the test. It's not a definition. The court did not say undue hardship is defined as follows. We haven't found a single case which said undue hardship is defined as follows. Instead, you've got a test. And the test has three parts. 1, 2, 3. One is based on current income and expenses. A debtor cannot maintain a minimal standard of living. That also relates to dependents.
Number 2 is that the debtor's state of affairs is likely to persist for a substantial portion of the repayment period for the student loans.
And the last one is there was a good faith effort to repay the loans. So when the district court looked at this in 1985, you had a debtor who was a woman who was 10 months out of her master's program. She had just reached the period where she was required to pay her student loans, hadn't made a payment, and she was seeking to discharge $9,000 of student loan debt.
Now, one thing with regard to the test, The way to look at this test is the first prong, the current income and expenses, is looking sort of at your present economic status of the individual filing for bankruptcy. The second one is looking to the future. Is it likely to persist for a substantial period of the student loan repayment period? And the third one looks at the past. What efforts has the debtor done in order to try to show that they have exhibited good faith? Now, there's nothing in the statute, of course, that at all mentions good faith. Many of the factors in these prongs were taken directly from a bankruptcy commission report, and so there's no statutory basis for the test, but it is a test that was employed by the court from some of the language of that bankruptcy commission report.
So what happens after the district court comes up with this three-part test is it goes up to the Second Circuit adopts it. There's nothing useful in the Second Circuit opinion other than we're adopting the test and they just restate it. The analysis all occurred at the district court level.
It is important to note, however, that at the time that the test was employed by the Brunner Court, students could still discharge their student loans after 5 years. So in one of the passages in the case, the Brunner Court specifically found that it was not unreasonable to hold that committing the debtor to a life of poverty for a term of the loan, generally 10 years, imposes undue hardship. So even within that decision, it's important to put it in context that this student could have had the opportunity still to discharge those student loans had she waited 5 years, and two, that the Brunner Court was looking at that as sort of in the backdrop of saying, well, even they didn't have any type of reference of saying or vision of saying that it would last longer than 10 years or the loan period.
Certainly every court that now looks at the Brunner test is noting that at the time this test was adopted, life was just different for debtors. Not only was debt less, in Brunner it was $9,000, but there was a time period in which if you just waited long enough, you didn't even have to do the test. And so that's absolutely relevant to whether or not the Brunner test should still be applied. Guess what? It is going to be applied, and the reason is because in every single circuit except the First and Eighth, they rapidly adopted this test, and the Ninth Circuit's no different. In 1998, the Ninth Circuit adopted this test in a case called United Student Aid Funds versus Pena, and that's 155 F3D 1108. So.
And again, in Pena, however, it is important to note that even under that case, the debtor could have still discharged their student loans after 7 years. So there was still an endpoint at which that debtor, if the undue hardship test had failed, which it didn't, they still had the opportunity to discharge those student loans after 7 years.
That's right. And so in every circuit, except the First and the Eighth, you're going to have to look at the Brunner test. And in the Ninth Circuit, you read these bankruptcy cases. Even today, you look at a case that's even months old, and the bankruptcy courts, one of their comments is we're bound to apply this because of this 1998 Ninth Circuit decision, and which, for the reasons Maggie just stated, may not have a lot of applicability anymore because there was a 7-year period that if you just waited, it could be discharged as normal. In the First and the Eighth Circuit, well, that's a different test. The First and the Eighth Circuit have rejected the Brunner test. They say that it ties the hands of bankruptcy judges too much. And we'll get to that in a little bit, but the First and Eighth Circuit apply a totality of the circumstances test, of which the factors they review include the 3 Brunner factors anyway. So if no matter what circuit you're in, you're going to have to look to these factors at some point, either in a totality situation or just exclusively those 3 factors.
Now, before we go into the Brunner test, I'm going to turn it over to Steve again to be aware to first do a preliminary investigation of whether the creditor, the loans that they're alleging are non-dischargeable, actually meet the test.
Yeah, it's, in these cases, when you take a look at what gets reported, in most cases, these are pro se debtors. They had to go to trial. They weren't able to afford an attorney. They show up pro se, and it's trial time. And many of these decisions just kind of recite as general background that the debtor stipulated that their loan qualified under 523A8, or that their loan was subject to the protection afforded student loans under 523A8. Well, you'll notice, I mean, as attorneys, you notice this kind of thing. Well, 523A8 doesn't actually say all loans of any kind relating to schools. Going back to the statute itself, there is a subpart to 523A8, A1, and A Romanet 2. And if you just look at Romanet 2 alone, it suggests that maybe you're out of luck, because Romanet 2 says it applies to an obligation to repay funds received as an educational benefit, scholarship, or stipend. Well, that's pretty broad, and just reading that you can go, well, I just don't have hope. But that's not the interpretation that at least one bankruptcy court gave it. And I think it's an important decision, even though it's just a bankruptcy court decision. That case was Nunez versus Key Education, RES period, /GLESI, and that bankruptcy case was 527 BR 410. In that case, the bankruptcy court said, prior to the 2005 amendments to the Bankruptcy Code, which made private student loan debt fall within 523A8. Prior to 2005, Romanets 1 and Romanets 2 of 523A8 capital A were all one phrase. And so therefore, it should still be read that way, that 523A8 capital A only applies to government debt. So that's what this bankruptcy court did, government debt. Within the category of government debt, there is essentially no way to get out of having 523A8 apply. It's just going to apply. But you will note that the language relating to private debt is different. It's completely different. Under 523A8B, student loan debt which relates to private debt only qualifies for this added protection if certain requirements are met. It's got to be a qualified education loan as defined in section 221D1 of the Internal Revenue Code. And then you take a look at what that means. And because lenders have the burden of proof as to whether these loans fall within it, if you got a private loan, you can make the lender jump through some hoops. First, they got to show that they're a qualified education loan under IRC 221. In order to do that, IRC 221 says that in order to be a qualified education loan, the loan must be incurred solely to pay qualified higher education expenses, which means the cost of attending an eligible educational institution as defined in 26 USC section 25AF2. So you then look to 26 USC section 25AF2, and that states that an eligible educational institution means an institution which is, among other things, eligible to participate in a program under Title IV of that Act. And it turns out the federal government provides a list of schools entitled to obtain Title IV funding. And so you've got this case in Nunez versus Key Education RES that I just mentioned, 527 BR 410. And in that case, a bankruptcy court determined that a loan did not qualify for 523A8 protection. And that was because it was private. And because it was private, they had to jump through all the hoops of 523A8B, and they couldn't. And the reason they couldn't is because the actual institution was not eligible to receive Title IV funding. It was a flight school in Oregon. The court looked at the document, the federal document that listed all the schools in Oregon eligible to receive Title IV funding, and the flight school was not on it. So this is not going to apply to that many cases. We get that. On the other hand, it's something that's obscure that if it's private debt, you shouldn't just stipulate that the private debt is going to fit within it. they've got the burden, and as soon as they prove that burden, the burden's all back on the debtor. So you don't give up at that point.
And I think Steve makes a good point that, especially because the Brunner test still is the dominant test and it's so strict in, as far as how the debtors need to comply, it is a useful exercise to at least check whether the creditor, who at that point has the burden to show whether their loan qualifies under 523A8, is even there.
So once you've taken a look at whether or not the loan is appropriate, you're going to be forced into a test pretty quickly. But before we get there, it's worth pausing for a moment to think about the situation you're about to get into. Because the situation you're about to get into is one in which it's going to be very difficult for a debtor to prove undue hardship. And so if you're in the First and the Eighth Circuit, you maybe don't need to think about this too much because you've got a totality of the circumstances approach, and you can always just muster the equities of the case, the facts that support your case. But if you're in the Ninth Circuit and and in the Ninth Circuit you've got judges saying, I'm not sure that the Brunner test is the right test to apply, now is the time in your briefing or even in your pre-case analytics of the situation to think about whether or not you want to jump into the Brunner test at all. You're going to have to, but maybe now's the time to make an argument that you shouldn't.
And I think two decisions in particular, which will be in the materials we will be sending you, is one out of the Seventh Circuit, in Ray Krieger, and one out of the Ninth Circuit, in Ray Roth. In those cases, in the Seventh Circuit, Chief Judge Easterbrook specifically said that it is important not to allow judicial gloss, such as the language in Brunner, to supersede the statute itself. So one of the principal arguments I think that needs to be at the forefront is this test even appropriate, given that there's no statutory authority for it under the statute or congressional authority. It was taken from a commission report, and the fact that when you first look at the statute, as far as analyzing whether there is undue hardship, the first line of inquiry should be to the statute itself. The other test in Ray Roth, Judge Pappas, in a concurring opinion, expressed the same frustration that the Brunner test should be reconsidered given the change in circumstances. Today, student loans are no longer, back then, when people were discharging student loans during the time of Ray Brunner, a lot of the student loans were between 5, maybe 10, maybe 15,000. Today, the student loans that people are graduating with, especially if they go to graduate school, can often rise above 200,000, which is not an insubstantial amount for somebody to repay, especially for graduates entering a weak job market.
So if you're an attorney and you're tasked with doing, a brief to the district court at this point, or the Ninth Circuit or the BAP, as to, how to go about doing this, a starting point is this Roth decision, and that's found at 490 BR 908. And the concurring opinion by Judge Pappas is it's a rallying cry that the Ninth Circuit needs to change. And if you're looking for more, extensive discussion as to why, we should not apply this test, look to any decision in the Eighth Circuit, because those judges in the Eighth Circuit, their decisions say, thank goodness we don't have to apply this test. It's not appropriate anymore.
And also in the Seventh Circuit, which does have the undue hardships test. In Ray Krieger, that case is 713 F3D 882, and that was the decision with Chief Judge Easterbrook.
So you're never going to you're never going to be able to avoid, having to talk about a test. You're going to have to talk about the Brunner test, and maybe the last thing you can tell a judge to have in their mind before they start applying this test is, do you even need a test? I mean, 523A8 doesn't have a test in it. 523A8 just has the words undue hardship. Why can't you just determine what undue hardship is, Judge? You're smart. You've seen thousands of these cases. Just determine what undue hardship is, and don't restrict yourself to any test at all. That being said, in the Ninth Circuit, courts then say we're bound to apply the Brunner test. So debtors have the burden of proof. Once the lender satisfies a lender's burden that the loan fits within 523A8, burden passes to the debtor, and you're going to have to show that you can satisfy that. If you want to try to discharge student loan debt, you're going to have to file a complaint. You're going to have to go to trial. And the debtor probably is going to have to testify. In the cases that you read on Brunner analysis, it always involves a court which put a debtor on a stand, or the debtor was put on a stand by someone else, and the court is evaluating the testimony of the debtor witness about their income and their expenses and their believability.
And it is important to note that it does have to be done by adversary proceeding, cannot be done by motion. So you will have to, and often those are much more costly as far as expenses, especially if you have to involve, if there is proof that there are some medical disability issues or other factors which may require expert testimony, that is an expense to take into account.
And it's not like a Section 524 situation of undue hardship where you just compare your Schedule I to Schedule J and subtract the two and say, whoops, I guess that proves my case. It's not like that. So, before commencing one of these adversaries, it really pays to have all your facts together because you're going to have to talk about them at length. So the first factor of the Brunner test is that the debtor has to show that the debtor cannot, based on current income expenses, maintain a minimal standard of living for himself or herself and his or her dependents. So it's the important word for me is current in this, because factor 2 goes to the future. This one just looks to present situation.
And so really what you're looking at is really analyzing the income of your debtor, the expenses, and making sure that the income and expenses, well, actually the expenses are reasonable, because the judge is going to take a look at some of those line items with regard to some of the expenses, and to ensure that this debtor is their current income or their ability to maintain a standard, a minimal standard of living, actually comports with the test of undue hardship.
So the PowerPoint slide you're looking at right now shows that there's 3 possible outcomes from the debtor just looking, or from the court looking at a debtor's Schedule I and J. Now I said that Schedule I and J wasn't the beginning and end of this analysis, and it's not. But what happens if you're looking at your Schedule I and J and it shows that you've got an extra $1,000 a month to make towards student loan payment? Well, that's outcome number 1. If your own schedules show that you've got a significant amount of money every month, and that your monthly payment on your student loan debt could fit comfortably within that number, it's very likely a court's not going to do much more of an analysis, and a court's going to say, well, there's nothing I can do. You can't even satisfy the first prong, that you're not able to make your monthly payment and live under a minimal standard of living, so you're going to lose.
Now, usually this factor is not going to be a huge issue, because most of the clients that you're going to see are going to be individuals that, in most cases, are going to easily meet this standard. And if not, you're going to look at their income, you're going to look at the expenses, and you're going to counsel your client and say, well, if you actually do have a substantial portion left over, the court is probably unlikely to even consider undue hardship.
I'm going to skip ahead to outcome, the third possible outcome, which is that you look at your Schedule I and you look at your Schedule J, and it shows that you really don't have much, if anything, or you have negative money left over at the end of every month. And that's honestly going to be what happens in most debtor cases. I mean, very few debtors are filing bankruptcy showing that they have an extensive amount of money at the end of every month after paying expenses. Court's not going to stop at that point. The court's going to look at all the expenses and chop them down if necessary. I mean, this is where debtors get put on the stand. This is where they get asked about the necessity of certain expenses. There's no such thing as one bankruptcy court decision in Alabama binding another bankruptcy court in Arizona. It's a case-by-case basis. The law requires the judges to look at all the factors, geographic location, number of dependents. It will happen. A judge will look at those expenses, and if the judge thinks that some of them are high, is going to chop them down. And at the end of chopping them down is going to look and see, well, okay, I've reduced expenses by, say, $500. That gives the debtor $500 more dollars every month. And I find that is enough to pay a student loan debt or not. Depends. I suppose it depends on if you have six-figure student loan debt or not. If you do, it's still not going to be enough.
And that's why I think this is the very initial inquiry. But like Steve mentioned earlier, most of the time this is not going to be the factor that's going to be the toughest for your client to overcome.
So the second possible outcome is something that has happened recently, and it is a fascinating question. And here is that question. Given that there are now federal programs that you can sign up for to repay your student loan debt over a period of years, 10 years, 25 years, which programs permit you to make monthly payments that are tied to your income, say 15% of your income after paying expenses, which may even permit you to pay zero if you are out of work or your income is too low? What do you do? What does a court do when you go into your adversary proceeding, you show your judge your income and expenses, and you show that you've got $50 left over at the end of every month, and that your student loan debt is $500 a month? And then the court says, but what about the fact that if you signed up for this student loan repayment plan, you might pay zero, and you might pay zero for the next 25 years, after which time your debt becomes, I'm not sure if discharged is the right term for it, but disappears, forgiven, and then it becomes a taxable event.
Exactly.
That is a complicated issue. The Ninth Circuit has said it is not dispositive, and that may be the best that we can get in the Ninth Circuit. That you get government attorneys, they show up, look at a Ninth Circuit case. In the last 2 years, a government attorney shows up and says, it's not fair to discharge this thing because they could just sign up for this program and pay nothing. So therefore, it is not possible for you to meet the first factor, Judge. It is impossible for you to ever find the first factor in a situation where a debtor can sign up for this program, because they will always be able to have a minimal standard of living, because that's what Congress wanted when they enacted this program. The Ninth Circuit will say, we're going to continue looking at this, but the reality is it's going to be an issue for your client. It is going to be something that you're just going to need to think about and probably even investigate at least a little bit.
I think also one of the things you have to go back to is the original intent of Brunner. In there, you can use language stating that requiring a debtor to live in poverty for 10 years it was reasonable to consider that as an undue hardship. And also, Judge Easterbrook in the In re Krieger decision in the Seventh Circuit, which does apply the Brunner test, basically said that the fact that he overturned a district court decision and said that it is an incorrect legal proposition that a debtor must always agree to a payment plan and forego a discharge, because that doesn't excuse the bankruptcy court from analyzing, does this individual in front of me satisfy the test of undue hardship? And in conjunction with that, in re Roth, some of the factors that you may want to use to support that is this debtor at the end of the day of the 25-year repayment plan going to be paying anything at all? And if one of the courts looked at in re Roth that if there is no payment forecast, even if the payment supposedly is zero, after 25 years, then the law should not impose negative consequences for not signing up for the program, because basically you're not doing anything that's going to put the lender in a better position, and you're basically just putting a debtor in a payment plan that really isn't going to help the creditor in any way, or the government as far as making any payments possible, and therefore excusing the judge altogether of making the analysis of whether the individual in front of you satisfies the undue hardship.
So you're an attorney, you're in front of a judge, and the government attorney is making that argument, and you've just got to remind this judge that they are not excused from their relieved of their duty to determine whether the debtor's student loans impose an undue hardship, and that the simple fact that these programs may be available doesn't automatically foreclose a debtor's ability to obtain a discharge. And you say, Judge, and otherwise, if you were to accept what the government attorney is saying, then you are placing the government, that particular attorney or that particular lender, it could even be a private lender, they have become the ones who have decided whether this debtor can get a discharge or not. And that's not their job, it is your job. So continue this analysis and make your decision based on the other factors.
Moreover, if you take that position to its fullest, that would mean no one would ever be able to satisfy the 523A8 undue hardship test, because if paying zero for 25 years is going to be used as the option that eliminates a debtor's ability to claim undue hardship, under that standard, almost no one would be able to comply with that standard. So I think those are arguments to tell the judge, look, 523A8 undue hardship standard stands on its own. The availability of these programs should not affect or impact your analysis of the facts before your court.
So you get past that one factor. The judge has to find all three in order to discharge this debt. You got to find all three. So factor 2 is that the state of affairs that you hopefully passed in analyzing factor 1 isn't going to improve or isn't going to get any better for the debtor for a significant portion of the repayment period of the student loan. So what does that mean? That it's in part is common sense, because if you've got a debtor that's unemployed, I don't make any money, I can satisfy factor 1 because I don't have any income. Well, here's where that loophole is closed, and that's factor 2, is are you someday going to make some income? If you are, then we're going to have to talk about the income you were likely to make. And it also makes it very difficult for young debtors to get a discharge. Regardless of how old their student loan debt is, it's going to be hard to prove if you're an able-bodied young person to show that you're just unlikely in the future to ever have increased amount of income.
I think in this test, however, there are some decisions that have been somewhat hopeful in recent years as far as applying the second prong. In Re Poly, a case in the 10th Circuit, the court specifically said that the courts need not require a certainty of hopelessness, but instead have to take a realistic look at the debtor's circumstances and ability to maintain adequate shelter, nutrition, and health care, and the like. And this again goes back to the Brenner standard of courts trying to impose a much harsher standard than really was required by the test, of trying to require debtors to basically live in poverty for years on end without an end in sight. And it's important that with each of these factors to remind the court that that was never the intent of the statute. In fact, in Ray Roth, Judge Pappas in the concurring opinion said, specifically stated that undue hardship test is too narrow and no longer reflects the reality and should be revised. And in his own words, he said, the Brenner test is a relic of a time long gone. Because of the issue that it was trying to cure at the time was people graduating out of undergrad or graduate education and rushing to the courthouse. He quickly, he noted in his concurring opinion that many outstanding loan debts are now decades old. These are not students that ran to the courthouse, filed for bankruptcy, trying to rid their obligations soon after graduations. These are students that have for many years have tried to repay these obligations, and due to the weak market and due to the undue hardship that they're experiencing in their life, just can no longer repay these debts.
So the Ninth Circuit has given us some benefit in this, analyzing this factor. In 2006, they came out with a decision called Education Credit Management Corp. versus NICE, NYS. and that's 446F3D938. And in that case, the Ninth Circuit said, well, when you're analyzing the second factor, you're looking at not a guarantee of inability to pay in the future, but likely inability to pay in the future, and that the Ninth Circuit said you're going to have to look at, all of the totality of the circumstances as to these factors, and then they listed 12 factors that non-exhaustive the courts can look at, and what do they include? Mental or physical disability of the debtor or debtor's dependents, which prevents employment or advancement. Incidentally, that was the case with the 1998 Ninth Circuit decision, Pena, which adopted the Brenner test. The Ninth Circuit found that the debtor was mentally impaired and so couldn't find employment in the future, and so they discharged debt for that reason. Other factors that the Ninth Circuit says courts need to look at are debtors' obligations to care for dependents, lack of or severely limited education, poor quality of education, lack of usable marketable job skills, underemployment. Those four, pretty interesting, given certain recent developments in bankruptcy, for instance, the bankruptcy case of Corinthian College, in which you've got courts making determinations that the education that some of those students received was useless. The Ninth Circuit says you absolutely need to take a look at the value of the education that the student received, and that this plays into the second factor.
Yes, and in Re Pena, although they didn't look at the value of the education as a separate factor, they did look at it when they analyzed the second prong, because the value of your education, of a debtor's education, is going to be relevant to the future ability of that debtor to be able to pay off that student loans. And that just makes sense. I mean, if somebody graduates from a for-profit institution and has no marketable skills but all the student loan debt, well, that's definitely going to impact their ability to repay that portion of their debt if their job prospects are limited because they haven't obtained any actual skills. And that's exactly what the court held in Pena, is that although that factor in and of itself wasn't seen as a separate factor, it was analyzed within the context of the second prong, and in disabling that debtor to basically repay those student loans in the future. So also, just going back to Nye, I did want to make a point. Often creditors, and I want to point to two decisions, both in Re Nye in the Ninth Circuit and in Re Poly in the Tenth Circuit. Sometimes creditors will argue or try to argue that a debtor has to have some sort of mental disability or physical disability with regard to analyzing their future ability to repay their loans. And in Re Nye really limited that analysis by saying that no exceptional circumstances needed to be a prerequisite to a discharge of the student loans. Although they can be considered, and of course they do impact the decision of the judge as far as seeing whether that debtor can repay those student loans, those weren't dispositive factors or requirements. And in Re Poly, the court on the 10th Circuit, the creditor ECMC argued that typically prospective undue hardship is proven by medical disability, but the courts quickly pointed out that the cases do not suggest that a medical disability is in any way a prerequisite to discharge student loans. So it's important to keep in mind that as these objections are being raised by the creditor, that there is case law stating otherwise, and that although they can help the case as far as showing undue hardship, they are not dispositive in saying that because they don't have a medical disability, because they don't have a physical disability, that therefore you are now foreclosed of that ability to meet that factor.
That's right. That's why Nye is such a benefit in the Ninth Circuit, because you can talk about things like the limited number of years remaining for the debtors in the debtor's work life, or age or other factors that prevent retraining or relocation, overall lack of assets, which could be used to repay the loan, and this may allow you to talk about things that normally the Brenner test doesn't allow you to talk about, such as things like, is it really fair if you have a, say, 45-year-old debtor to make them have a taxable event when they're 70 years old and have to repay, be taxed on the forgiveness of their student loan debt if they were to go into one of these income repayment plans and make that argument at the second, with regards to the second factor of the Brunner test as opposed to the first or the third.
And I will close with the second factor before we get to the third, which is an in re poly in the 10th Circuit. The court said that you should base the estimation of debtors' prospects in the future on specific articulable facts, not unfounded optimism, and be limited to the foreseeable future, at most the term of the loan. So that type of language kind of limits the scope of, anybody, I guess, could posit and say, well, this individual could win the lottery or, get an inheritance. But I think this really sets forth a standard of saying these have to be realistic, specific, articulable facts. They can't just be sort of this unfounded optimism that will go indefinitely in order to just defeat your debtor's application for undue hardship.
So the third factor is the amorphous, that the debtor has made good faith efforts to repay the loans. And it seems maybe it's not amorphous because it looks to something very specific, effort to repay the loans. But courts either strictly interpret this or don't, depending on other factors. So it's almost an amorphous good faith test. For example, there are cases in which courts using the Brunner test will discharge a debtor's student loan debt even though they've never made a payment before in their life on student loan debt. You would think that that would be impossible reading this third part of the test, but it's not. This is the factor that makes it so you probably, before you commence a bankruptcy case, probably have to look at the availability of a federal repayment plan or anything else. It may require you, although if you don't, because if you don't, you're going to have to come up with a reason why you didn't, to call a lender and say, hey, can I reduce my monthly amount to you? Can you forgive some of the principal? To at least make the attempt. Because it seems like in these cases, factor 3 has become an overall discussion of a debtor's attempt to not just pay in the past, because lots of times payments are difficult if your expenses are high, but to investigate whether or not it was possible to pay less. And now that there are other options for doing that, you've got to be prepared to, if you don't do that, to at least explain why you didn't even bother.
It is important to note, though, that in re poly, a 10th Circuit case, the court did find that the good faith requirement can be satisfied by showing that the debtor was actively minimizing their current household living expenses and maximizing their personal and professional resources. So although it is important to look at some of these repayments, and we'll talk a little bit about some of the arguments that you can make in addressing this good faith standard, I think it's important to bring back the core to say, okay, what realistically can the debtor do in order to show that they've maximized their income and minimize their expenses? And that's where I think it's also useful to look at the debtor's education. Have they maxed out? That was one of the factors they look at. NIE. The debtor in that case had basically topped out at her career and was going to be retiring soon. And one of the factors you may want to include that's relevant is Social Security can be garnished by student loans. So if those debts are not discharged, the government can garnish your Social Security. And I think that's a very compelling factor to bring out, especially with many people who have student loans that are decades old, entering their 50s and 60s, and this could border on somebody becoming homeless, because if they're garnishing their Social Security and that is their only income, that could be a factor very persuasive to the court to say this definitely will cause an undue hardship. And some of the factors to include, and we'll go into it now just because I see we are running up close against the time, is will the payment plan really enable the debtor to make any payment at all? If the repayment plan that is being offered to the debtor is basically saying that you have no payment at all, then I think that's strong evidence that really, why should we wait 25 years if the prospects are so bleak and the situation is so difficult financially, it's only set to get worse with age, especially with many of the debtors in the cases we've cited. They're getting older. They may have been looking for jobs for many years, and other than unfounded optimism, it is unlikely that their prospects are going to improve in the future. So why go through this sort of ruse of saying, let's put them on a 25-year repayment plan, when their situation at 25 years, at the end of 25 years, is not going to be any better. And in addition, during that time, there is still the possibility that they may not be able to comply with all of the reporting requirements of the IBR, and at the very end possibly even have tax consequences, because the debt in that case is not discharged, it's forgiven, which for some at the end of 25 years could be a taxable event. That doesn't necessarily mean it will be, but it could be, and that's after 25 years of strict compliance with the reporting requirements of the IBR, which is something to bring up within your case.
Yeah. So to the extent we're just looking with this third factor, we're still just looking at the past. You know, debtors are going to have problems if their records show that they had the ability in the past to make loan payments but never even bothered. That's going to be a problem. If you can, in that case, you're going to have to try to muster evidence saying that it was just too difficult. It was just too difficult 5 years ago to make my student loan payments, and you know, a case you can cite for that is England versus United States 264 BR 38. But you've just got to be able to show that evidence. And you know, I'm not sure that we are even talking about the past anymore with factor 3, because as Maggie was talking about, you know, the availability of these repayment programs almost means that courts are just asking you about what's best for you in the next 25 years. Does it, you know, if you failed to sign up for a program when they sent you a letter saying please sign up, you can sign up any moment, all you have to do is accept, you know, does that require the court to evaluate whether or not these plans are appropriate? Maybe it does, and you have a lot of arguments you can make that these plans weren't appropriate.
Also, some of the factors, and this is in the Ninth Circuit Ross decision that you may want to look at, is have the debtor's wages been garnished? Have there been any payments that have been made? Because lack of even minimal payments is not necessarily dispositive of a lack of good faith if your client actually didn't have the ability to pay. Also, payments that were garnished, those were seen as a factor of demonstrating good faith, because those payments were recovered by the debtor, although not voluntarily. I mean, those payments were still recovered by the lender. Did the debtor have a lack of knowledge of these payments plans? And also with some of them, there are some requirements. For example, with some of the programs, you actually have to be current in order to be able to apply for them. There, in Headland, another case where a debtor was looking to try to negotiate a payment plan, he actually was not eligible for the income-based repayment plan because he was in default. So these are all factors that whatever the debtor has done, whether maximize their income, minimize their expenses, mailed in an application and just never heard back from the lender, had their wages garnished or their tax refund intercepted. These are all factors that demonstrate that go to the court considering the factor 3 of good faith.
And I think that's a good transition now for us to move away from the Brunner test and move to another test, the First and Eighth Circuit test, which may now be very similar, because Brunner test almost has to be expanded to talk about other things. Well, that's what the First and Eighth Circuit do. They talk about everything, and we're not just going to read the list of the stuff that's now appearing on your screen, but it's everything. And the Brunner factors are in there, but there's other things too. Whenever you read a First or Eighth Circuit decision in which they discharge a student loan debt, it really is true that these courts just say, we're happy we can apply this test and we don't do something more restrictive. You look at these lists, these factors, and it seems like, well, maybe it is, really the same test because they look at the same things, but no court is required, but at least in the First and Eighth Circuit, you're not required to go through a list, make a finding that each of the 3 factors is met, because otherwise the debtor loses. There was a decision just a few days ago in Missouri out of the 8th Circuit, the case of Abney versus United States Department of Education, and that's at 2015 BANKR.Lexus 3849, in which a court did discharge a debtor student loan, and the court did it in a way, did it under facts that would not have satisfied the Brunner test. And because the facts were that this was an older debtor in their 40s, he had made some attempts to pay on his debt, still had $70,000 left over, was working pretty hard, so no question that he was, doing what he could to maximize his income. But he was about to have one of his major expenses disappear, and that expense was child care payments. And the government attorney went in and argued, Judge, this guy's, starting a few months from now, he's not going to have this major expense in his life anymore. He's going to be able to make student loan payments. And the court looked at everything and said, after saying, thank goodness we don't have to apply the Brunner test, said, you know what? We're discharging this debt. We're discharging this debt because it's just not fair. It's not fair to make people sign up for these loan repayment programs which will condemn them to a life of poverty. It's not fair to take this debtor who's got $500 in their 401k program and say that he basically can never put money into his 401k program again. So, it's another rallying cry for the change that judges in the 9th Circuit, at least in lower courts in the 9th Circuit, seem like they want to see. And so take a look at that case. Take a look at cases out of the 8th Circuit that apply this stuff, and they say this is what we are supposed to do as bankruptcy judges, is get rid of debts like this.
And in fact, in In re Roth, the concurring opinion from Judge Pappas, he not only questions Brunner, but recommends that we look towards or veer towards a totality of circumstances so that judges, again, have the discretion of looking at the facts before them with each individual debtor rather than applying this very stringent mechanical test that's not even in the statute.
So it's, it's a tool that you can use in the 9th Circuit, is to point out, hey judge, before you, deny this debtor discharge, just realize that other judges applying the same 2 words in this statute could rule differently and have ruled differently. So maybe you should either expansively interpret Brunner or just come up with your own interpretation of Brunner to discharge this debt.
And it's always useful to go back to the Brunner case. I read it a couple of times after a few years of not looking at it, and actually the case, provides some good limitations as far as what the court was looking at the time. Again, you want to remind the court that at the time the Brunner test was instituted or applied by the 2nd Circuit, that debtors could still discharge their loans automatically without this undue hardship analysis after 5 years. And so now you're taking a very stringent test and applying it to a time where none of those time limitations are now in place. And therefore, the only way that a debtor can now discharge their student loans is if they prove undue hardship. And so I thought, although the Brunner test was harsh, another circumstance that you want to, another contrast that you want to put as far as now and then is the amount of debt. Students were graduating, as I mentioned earlier, between $5,000 to maybe $15,000 if you look at past cases under undue hardship during the 70s, whereas now it's over $200,000 that people are graduating with obligations that, in most likelihood, especially if they graduate from for-profit schools, these are debts that are just never going to go away. And even if trying to impose this 25-year repayment plan is not really going to allow the government to recoup those funds, because there are limited job prospects, because they obtain no skills, in many cases to their detriment, by going to schools that provided no skills, and oftentimes that reputation is known within that community. So it's actually more of a detriment when these students graduate from a school, especially in this case we just had Corinthian that just filed for bankruptcy, and many of these schools have participated in very, in some cases, questionable marketing tactics, bordering on fraud with regard to placement rates and basically getting students to come in, take the student loans, because they're not going to bear the burden. If the student can't pay the loans, that's going to go to the government.
Well, thank you everyone for spending time with us. We are going to be emailing everyone MCLE materials. We're going to be emailing everyone printed materials as well. Our email addresses are in the front part of this presentation, and you can email us as you like. Thank you very much for your time.
Thank you. We hope you enjoyed the presentation.
We hope you enjoyed the presentation.